mining results in negative impact for the surrounding communities. It is only fair that communities, landowners, and those impacted by the activity to partake in the process issuing these licenses. Hi everyone, and welcome to SA Mining Desk. Today, we're diving into a topic that can quite literally determine the fate of a mining project: consultation. This isn't just a nice-to-have, it is a non-negotiable legal requirement. Yet, it is the most misunderstood, dreaded, and litigated part of any mining project. In fact, the courts have been very clear: if you undermine consultation, your mining right can be set aside. So, let's jump in and look at how to do it right. The legal framework. In the MPRDA, the Mineral and Petroleum Resources Development Act, after an application is accepted, the applicant, which includes their environmental practitioner, must meaningfully consult with interested and affected parties, or IAPs. This isn't a freestyle process. It must follow the strict procedures laid out in the EIA Regulations 2014. These same rules also apply when you're consulting on a social and labor plan, which is a key requirement for any mining right. What is meaningful consultation? The Mineral and Petroleum Development Regulations define meaningful consultation with an emphasis on the applicant's conduct in facilitating the consultation. Meaningful consultation means that an applicant consult in good faith, which means acting with honesty and sincerity as you consult with IAPs. Facilitate participation such that reasonable opportunity is given to the consulted party to provide comments. Provide relevant information about the proposed activities to enable the consulted party to make an informed decision on the matter. The EIA Regulations outlines the procedure to be followed in conducting the public participation, such that I and AP are given a 30-day period to comment on the application. I and AP are provided access to all information that could influence a decision, unless it's protected by law. The applicant makes use of the most effective method of communication. The purpose of consultation, which is to promote procedural fairness in administrative decision-making, ensure meaningful participation by affected parties, enable informed decision-making by both the applicant and the competent authority, and facilitate proper identification of negative impact of the proposed mining project and their mitigating measures. The goal of consultation changes depending on who you're talking to, nature of their rights or interests, and the statutory protections applicable to them. Let us look at the purpose of consultation for some of INAP to be consulted. 1. Landowners and lawful occupiers. The goal here is to find a reasonable accommodation. We're looking for a balance between the owner's right to use their surface land and the miner's right to get to the minerals underneath. The Constitutional Court in the Bangwenyama case made it clear you must inform the owner in writing, provide enough detail for them to assess the impact on their right, and try to reach an agreement. It's important to note the law doesn't require an agreement to be reached between the parties to grant a right. However, failure to conduct meaningful consultation may compromise the mining project. Note should also be taken that landowners and lawful occupiers retain the right to claim compensation or damages should they suffer loss as a result of mining activities at a later stage. Informal land rights holders. Consultation with informal land rights holders serves a fundamentally different purpose. Here, the objective is not merely consultation, but the obtaining of consent, as per the Interim Protection of Informal Land Rights Act, 1996. The Constitutional Court in Maledu and others versus Itareling, Bakatla Mineral Resources Private Limited, and later in Grace Masele, confirmed that the MPRDA and IPIRL must be read together so that each statute is allowed to fulfill its constitutional purpose. The High Court in Baladi and others versus Minister of Mineral Resources held that informal land rights holders must give full and informed consent. Such consent must be obtained in accordance with the community's own customs and decision-making processes, and in the absence of such consent, the minister lacks the legal authority to grant a mining right. The general public. Public consultation is rooted in transparency.
It ensures that anyone affected is informed and given a chance to object. While you don't need a total consensus from the public, you must genuinely consider and respond to their inputs.
4. Government stakeholders. Mining activities intersect with a wide range of regulatory regimes administered by different organs of state, including but not limited to water use, Department of Water and Sanitation, land use planning and rezoning, municipal planning authorities, and heritage resources, SAHRA, or provincial heritage authorities, just to name a few. The purpose of consulting government stakeholders is to enable coordination between regulatory authorities, allow relevant departments to comment on issues falling within their statutory mandates, and ensure that decision-making is integrated, informed, and compliant with all applicable legislation. This intergovernmental consultation supports cooperative governance as required by the Constitution. 5. Traditional authorities. If you're mining on communal land, you must consult traditional councils. But remember, this is in addition to consulting the actual community members, not a shortcut to bypass them. Where the land applied for is registered or to be registered in the name of the community, the process of Section 104 of the MPRDA will be triggered. This means that the community should be given a real opportunity to bring a Section 104 application before a decision is taken on the competing application should the community wish to do so. The department must inform the community of the application and its impact on the community's ability to apply for preferential mining or prospecting right, and failure to do so may result in breach of procedural fairness. Though the responsibility to bring such awareness rests with the department, as an applicant, you are required to bring all relevant information when consulting INP. It is strongly advised that such would fall under the category of relevant information. Key takeaways for Part 1. Consultation is mandatory. It is the make or break of your license. The main goal of consultation is to give INP a chance to comment on matters that will affect them. This goal changes depending on who you are talking to, nature of their rights or interests, and the statutory protections applicable to them. Meaningful consultation requires that the party consulting consult in good faith, avail all relevant information, and afford INP a reasonable opportunity to comment. Consultation must be done over a period of 30 days, and the most effective method of consultation must be used. The main goal of consultation is to give INP a chance to comment on matters that will affect them. Thank you for watching SA Mining Desk. If you found the video informative, please like, comment, and subscribe to our channel. Join us in Part 2, where we'll look at exactly who needs to be consulted and how to identify and notify INP. Until next time, take care.